Welcome to the channel Scientellectual. In this video, we are discussing Chapter 7 Provisions for Secrecy of Certain Inventions. It comes under Indian Patents Act 1970. The sections that will be covered under Chapter 7 are Section 35 to 42. Section 35 Secrecy Directions relating to inventions relevant for defense purposes. Subsection 1. The invention, if it is one of a class notified by the central government as relevant for defense purpose, the controller may give directions for prohibiting or restricting the publication of information with respect to the invention or the communication of such information. Now, central government has notified some classes that are relevant for defense purpose. If any patent application falls under that class, then the controller may give directions to prohibit or to restrict the publication of such application. Subsection 2. Directions is given as referred to in subsection 1. The steps are like that. The controller gives notice to the application and of the directions to the central government. That is, the controller finds any patent application which is relevant for defense purpose. Then he gives notice to the central government that such direction has been given. Next step is the central government considers whether the publication of the invention is prejudicial to the defense of India. Next, if they find that the invention is not prejudicial, they give notice to the controller. And then the controller revokes the direction and notifies the applicant accordingly. And in that case, there is no restriction or prohibition to the publication of such application. Section 35, subsection 3. Without prejudice to the provisions contained in subsection 1, in case the controller has not given any direction to the invention relevant for defense purposes, then at any time before the grant of the patent, the central government will notify the controller. And if the invention were one of the class notified by the central government, the controller shall give notice to the central government of the directions issued by him. That is, if in any case the controller missed that the patent application is relevant for defense purpose and central government finds that the patent application is related to defense purpose, then the central government notifies the controller that this invention is falling under the class notified by central government. In that case, the controller then gives notice to the central government and directs accordingly. Section 36. Secrecy directions to be periodically reviewed. Subsection 1. Whether an invention in respect of which the direction has been given under Section 35, that is, the controller has given secrecy direction under Section 35 that this patent application is falling under the class notified by the central government and thus relevant to the defense purpose. And so, there is prohibition or restriction to the publication of that application. It continues to be relevant for defense purposes shall be considered by the central government at an interval of 6 months or on a request made by the applicant which is found to be reasonable by the controller. If secrecy direction is given, then the central government reviews the application every 6 months to check whether it is still relevant to the defense purpose. If the central government finds that the publication of the invention would no longer prejudicial to the defense of India, or in case of an application filed by foreign applicant, it is found that the invention is published outside India, then central government gives notice to the controller to revoke the direction, and controller shall thereupon revoke the direction given by him. Subsection 2. The result of every reconsideration under subsection 1 shall be communicated to the applicant within such time and manner as prescribed. The relevant rule is Rule 72(1). The result of every reconsideration under Section 36 shall be communicated to the applicant for patent within 15 days of receipt of notice by the controller. Section 37. Consequences of secrecy direction. Subsection 1 says, so long as any direction under Section 35 are in force, in respect of any application, A. The controller shall not pass an order refusing to grant the application, and B. No appeal shall lie from any order of the controller passed in respect thereof. That is, if there is secrecy direction which is in force in respect of any patent application, the controller shall not refuse the grant of the patent application during that secrecy direction period, and B. There is no appeal for any order of controller passed with respect to that patent application, provided, subject to the directions, proceed up to the stage of the grant of the patent will continue, but the application and specification found to be in order of the grant shall not be published, and no patent shall be granted in pursuance of that application. Subsection 2 under Section 37. Directions have been given under Section 35. The invention, if it is in order for grant during the continuance in force of direction, then A. If during the continuance of the secrecy direction any use of invention is made by or on behalf of or to the order of the government, the provision of Section 100, 101 and 103 will apply in relation to that use, as if the patent has been granted for invention. And B. If it appears to the central government that the applicant for the patent has suffered any hardship to maintain the secrecy direction, the central government may make him payment by way of solatium as appears to the central government to be reasonable. Subsection 3. Where a patent is granted in pursuance of an application with respect to which directions have been given under Section 35, that is, secrecy direction has been given in respect of any patent application, then no renewal fee shall be payable in respect of that period during which the secrecy direction is in force. Section 38. Revocation of secrecy directions and extension of time. When any direction under Section 35, that is secrecy direction, is revoked by the controller, then if he thinks fit, he may extend the time for doing anything required or authorized to be done by under this Act with respect to the application. That is, during secrecy direction, if any action during prosecution of the patent application was pending, then the controller may give extra time to complete that pending action. The relevant rule is Rule 72. The extension of time to be given for doing anything required shall not exceed the period for which direction given by the central government was in force. That is, the time period for secrecy direction, if it was say 8 months, then 8 months of extension of time will be given. That is, the time for secrecy direction will be given for completing the pending action. Section 39. Residents not to apply for patents outside India without prior permission. Subsection 1 says, no person of India shall, except under authority of written permit in the manner prescribed and granted by or on behalf of the controller, make or cause to be made an application outside India for grant of patent for an invention. That is, no Indian resident can make any patent application outside India without the permission of the controller, unless A. the application for patent for the same invention has been made in India not less than 6 weeks before the application outside India. That is, unless if he files in India first and then after 6 weeks he can file outside the India. Or B, either no secrecy direction under section 35 is there or all such directions have been revoked. That is, there won't be any secrecy direction in force while filing the application outside India. Section 39, subsection 2. The controller shall dispose of every such application within such period as may be prescribed, provided that if the invention is relevant for defense purpose or atomic energy, the controller shall not grant permit without prior consent of the central government. That is, if any patent application is related to defense purpose or related to atomic energy, the controller first gives notice to the central government. If they permit, then only the applicant can file the patent application outside India. Subsection 3. This section shall not apply in relation to any invention for which the application for patent for protection has first been filed in a country outside India by a person resident outside India. That is, this section does not deal with the resident that are outside India. The relevant rule is Rule 71. Permission for making patent application outside India under Section 39. It says that the request for permission for making patent application outside India is to be made through Form 25. The controller shall dispose the request within a period of 21 days from the date of filing of such request, provided that in case of invention is related to defense or related to atomic energy, the period of 21 days will be counted from the date of receipt of consent from the central government. Section 40. Liability for contravention of Section 35 and Section 39. If any person contravenes the secrecy direction given by the controller under Section 35 or makes or causes an application for grant of patent outside India contravening Section 39, then the application for patent shall be deemed to be abandoned and the patent granted, if any, shall be revoked under Section 64. Section 41. Finality of orders of controller and central government. All orders of the controller giving the direction related to secrecy, as well as all order of the central government under this chapter is final, and there is no call in question in the court on that ground. Section 42. Savings respecting disclosure to government. Nothing will prevent the disclosure by the government any information regarding the patent application to the central government to examine whether the patent application is related to the secrecy direction, or if any secrecy direction was made, whether it is to be revoked. Here we show the Form 25 with relevant fee. Thank you all the viewers for watching the video. Please give a like and share and subscribe our channel Scientellectual. We are providing all the necessary informations regarding sections, rules, forms and fees related to Indian Patents Act 1970, which is very helpful during the preparation of Indian Patent Agent exam. Thank you.